Welcome to our channel, CAD Ventures NG Law, Obata Chambers. I am John Choka Obata, an attorney. With me is my senior partner, Paul Machuku Obata. We are planning and environmental lawyers and property consultants. In this session, we shall introduce to you the concept of what environmental law is, and we will focus on the main objective of protection, conservation, and preservation of the environment. Please do come along with us by subscribing to our channel, like our videos, share them, and also hit the notification button. Environment refers to our immediate surroundings, the sum of physical, chemical, and biotic conditions, such as climate, soil, or living influences, surrounding an organism, community, or object. Environment is divided into natural, that is, air, water, land, wildlife, and other living things, including landscapes and human-made components. Natural and human-made components. Environmental law, therefore, is law relating to the protection of public health, natural and human-made surroundings. It can also be said to mean pollution control law. Human exploitation of natural resources is a continuing phenomenon which is beginning to pose major concern. Please take us into that.
Thank you, John. Environmental law is an inevitable aspect of the environment which provides protection against the pollution of the environment and equally facilitates how it is developed or not developed. The main objective of protection, conservation, and preservation of the environment is achieved when law is mobilized to operate with science and technology. Law is strict and immutable, while science is precarious, yes, prone to change, given to change. But technology here is the involvement of best practices in harnessing of natural resources and other components of the environment. Yes, it's of great concern because we do know that obsolete technology would definitely impact more negatively on the environment. There is obsolete technology, there is modern technology, and there is sophisticated technology. And the type of technology or the kind of technology employed in the harnessing of natural resources in the environment is of a great concern here. So with such legal basis as the national policy on the environment, we have the National Policy of the Environment, 1989. And it is administered by the Ministry of Environment. And the purpose of this administration is to vigorously pursue the protection of the Nigerian environment, regulating and regularizing it against misuse and abuse by human elements who are anchors and beneficiaries thereof. So lawyers have an opportunity to play a key role in conserving, preserving, and protecting the environment and resources for the good future of humankind. What is conservation? Conservation is the supervision, the management, and the maintenance of the natural resources. That is the protection, the improvement and wise use of natural resources in a way that ensures its continuous availability with social as well as economic benefits. So the courts play a secondary role in the solution of environmental ills and on the impact of environmental damage. Law has made provisions against abuse of the environment, such as the air, the land, water, the wildlife, and so on. So this is done by penal techniques, by administrative regulatory techniques, and by grievance remedial techniques. The fines, the liabilities, and the important lines of policy are drawn in coping with it. So here, we find the courts perform only a backup function. And the job is primarily one cut out for the executive arm of government, the legislative and the administrative arms of government. So for the environment to be protected, to be preserved, for it to be effective, all tiers of government and the public and community participation is inevitable. You see, environmental law is as old as Nigeria itself, and derives its validity from the general sources of Nigerian law, such as the English Statute of General Application, the Common Law of England, and the doctrines of equity in force as of January 1st, 1900, such as the common law torts of negligence, nuisance, public or private, trespass, that is trespass to land, and by the rule in Ryland versus Fletcher, 1866. These were introduced into Nigerian legislation. And so, another source is the English law, the statutes, and the subsidiary legislations made on or before 1st October 1960 and still in force. And then we have the Nigerian Constitution also as a source of environmental law. In the 1999 Constitution of the Federal Republic of Nigeria, in section 20, it is stated there that the states shall protect and improve the environment and safeguard the water, the air, the land, and wildlife of Nigeria. And so, it is a source, one of the sources of environmental law in Nigeria. And secondly, we have in that regard the judicial precedents, the Nigerian case law. There are also contributions of customary law to the protection of the environment, which is noticeable from the angle of conservation practices they promote, as some animals are protected by custom. Some animals are protected by custom. There are sacredness and taboos placed on some of these animals with sanctions on violators. Though this is appreciated and it is recognized, but conservation is more than that. And so law is unique because its prescriptions are backed by sanctions for maintenance of public order, to suppress deviant behaviors and facilitate cooperative actions. securing obedience. Other sources of Nigerian of the environmental law in Nigeria are the statutes passed by legislature of Nigeria, the acts, the decrees by the military government, and the edicts by the states. We have other national statutes such as the Criminal Code Act, Section 243 to 248, which provides for offenses against public health. There is also the Harmful Waste Special Criminal Provision Act, the FEPA Act, the Federal Environmental Protection Agency Act of 1992, which was overridden by the National Environmental Standards and Regulation Agency Act of 2007. Then there is also the Endangered Species Act, Control of Trade and Traffic. You see? Also the forest laws of Nigeria. The forest laws, the forest and wildlife laws of Nigeria, which ordinarily is referred to as the game laws. It's the enforcement of laws regulating forests and wildlife of Nigeria was the first wildlife management tool preceding refuge and a game reserve creation, the establishment of the zoos, and the law enforcement is the basic tool of management and protection of Nigeria's wildlife species as a national heritage for future generations. Yes, that is the purpose of the conservation, as a national heritage for future generations. So conservation and protection of wildlife in Nigeria is still governed by the three old game laws which emerged with the creation of states in 1967. And each wildlife law had its own territorial coverage. We have the wildlife law of Eastern Nigeria, 1916, and then the Western Nigeria wildlife law of 1928, and the Northern Nigeria wildlife law of 1963. They are referred to as game laws. Game laws. An attempt was made to have a unified wildlife conservation law in 1973 by the then National Wildlife Conservation Committee. It was titled the National Fauna Conservation Law. But alas, the Endangered Species Decree number 11 of 1985 came in to strengthen forest and wildlife law in Nigeria. And see, all these laws are the sources of environmental law in Nigeria. And then we also have the state legislations, such as the waste management authorities, the state environmental protection agencies, and then lastly, the application of international law on environmental crime. You see, Nigeria has been signatory to conventions and treaties, and some of the outcomes have been domesticated into our laws. These are sources of environmental law in Nigeria. Please don't forget, subscribe to our channel and hit the notification button so that you don't miss any of our planning and environmental law related videos.